Okay, welcome to this Building Safety Act webinar, What You Need to Know, with myself hosting Kane Blatchford. I'm from T&B Contractors. Welcome. Next slide, please. So, T&B Contractors, we're a main contractor. We're an SME. We do construction works ranging from up to £10 million worth of work. And you can see we do lots of social value, lots of great stuff on living wage and ISO. So generally good all round. Next slide, please. But the meat on the bones of this webinar is going to be given by Birketts, who are our legal advisors. They assist us when we need assistance. They are very good, and most recently have helped us to revise our T's and C's, in part in relation to a response to the Building Safety Act. Next slide, please. So that's us. You've got myself, Kane Blatchford. Like I say, I'm the HSQE Director here at T&B, and the next person you'll be hearing from is Emma, Senior Associate Construction and Engineering, and then we're following on from that. Catherine will be talking through the sort of implications and of the Building Safety Act. Next slide, please. And what we're going to go through today is just a really brief overview of our understanding, what the regulator's responsibilities we've got in there, change management. People have heard of this term, the golden thread, and from our perspective, from TB's perspective, what we've been trying to do, we've been trying to make sure that we're up to date, and we've been prepared for the changes that have been coming in, which has been quite challenging because I think there's not many people that do know exactly how this thing should operate. So it's trying to get ready for something that no one really knows what we should be doing. So it'd be interesting to see if there's any questions on that coming up later. I should have said at the start that the session will be recorded. So anybody wants to have this, and we're going to be emailing out to everybody at the end as well. So the session will be recorded, and there will be room for questions. So if you want to click on your questions box, we'll try to endeavour to answer those questions at the end of the session. So yeah, just put the questions in and see what we can do at the end. So next slide, please. And without further ado, now I'm going to hand you over to Emma, who's going to go through the regulators, responsibilities, competency and evidence. Thank you, Emma.
Thank you, Kane. Hello, I'm Emma from Birketts. I'm going to be talking you through some key points on the new regulators and responsibilities and some things on the topics of competency and evidence. Next slide, please. We're going to kick off with a poll. If I could ask all of you to, when prompted, if you can click true or false, whether or not the Building Safety Act is only relevant for high-risk buildings. We'll come back to your answers in a little while, and we'll find out what you think, and I'll tell you what the answers are. Next slide, please. Oh, false. Overwhelming result there. Everyone agrees it's false. Next slide, please. Before we come to the answer, just wanted to talk you through a bit on the background to the Building Safety Act. Obviously, it's arisen out of the Grenfell tragedy, where really a torch was shone on the extent to which the market has failed to self-regulate in regard to fire and structural safety. And the Act achieved royal assent in 2022, and really it can't really be understated. It is the biggest reform in building safety regulation for a generation. We have got 12,500 approximately of multi-occupant buildings, and 88% are higher risk buildings, and that's in the construction phase, certainly that's defined as any dwellings, any buildings that are over 18 metres or 7 stories in height with 2 or more residential units. And really, this act it's got a load of sections in it which amend other bits of legislation, and it's been coming into force incrementally to really bring about cultural change within the industry. So we're going to find out the answer to our poll now on the next slide, please. Yes, so you were right, it's false. The Building Safety Act applies to all buildings, and it's just that it has additional requirements for high risk buildings. It's the foundation of the new building safety regime. And we'll see above there, you've got a quote from Dame Judith Hackett, which really sets the backdrop for this act. And she describes it as a very different approach to the regulatory framework for high-rise residential buildings, which recognises their complex systems where the actions of many different people can compromise the integrity of that system. And I think a big thrust there is the way that the Act is encouraging people to take ownership of their duties and the part that they play in building that complex system. Next slide, please. So just a whistle-stop tour really through where we are now and how we've got here. The Building Safety Act regime has come into force incrementally. In April, we had the new regime started really, and introduction of new duties and terminology, and all existing high-risk buildings had to be registered via the HSE by the end of September. From October this year, we've had a lot more of the mechanics really starting to become operational. So you've got the 3 gateways, so planning, pre-construction and pre-occupation. There's, it's really, it is a gateway 1, 2 and 3 where you need to get building safety regulator approval before you can proceed. The Building Safety Regulator is now building control for all high-risk buildings, and you no longer can use a private company to take that role for you. The regulator has started its review of existing registered high-risk buildings. Obviously, with resources being as they are, they're having to prioritise the highest risk ones first, and there's a lot of them. So, they will be working through their caseload there. You've got registration opening from the 1st of October. That's opened for any new build high risk buildings, and that includes works to an existing building to turn it into a high risk building. We have new competency frameworks, which is relevant for all buildings, not just high risk buildings, and new offences and enforcement action that may be taken, and that's also in regard to all buildings. So we will come on to those later in the talk. And just a note on some transitional arrangements. So the new regime really impacts on projects where you've got planning consent after the 1st of October or your works haven't started by the 6th of April. So if you had planning before that, the 1st of October day, and your works start by the 6th of April next year, you should be under the old regime. But for high risk buildings, you do need to have achieved sufficient progress by the 6th of April, and that's generally some sort of permanent building work, whether it's foundations or if it's not a new build, then other permanent building works, and then you can avoid gateways 2 and 3, so that's pre-construction and pre-occupation approvals by the regulator. Next slide, please. So the regulator, Building Safety Regulator, is part of the HSE. They are there to oversee safety and standards for all buildings, but clearly they're going to be focusing on high risk buildings. Some of the key points listed below on the slide there, building inspectors are now a regulated profession. They're regulated by the Building Safety Regulator. The regulator will take action against any building owners, duty holders and accountable persons that don't comply with their obligations. We'll come on to those roles in due course in this webinar. The regulator is also leading on improving competence in the industry, and really the thing to understand is that they're having a bit of a carrot and stick approach, if you like, to bringing about this cultural change by encouraging people to upskill and to be competent in their role in terms of fire safety and fire and structural safety, and encouraging learning really and understanding in the industry. But they're also they've also got their enforcement powers now, which are the sticks that they'll be using if necessary. So our new scheme for the higher risk buildings, there's going to be a register of higher risk buildings. There's a requirement for this elaborately named golden thread of information, which is essentially electronically stored information in regard to fire and structural safety, all that key data in regard to the building, which is a live file which needs to be maintained. The regulator will also be reviewing safety case reports, which are to be prepared by the accountable person. So that accountable person really is a role that's undertaken in the occupation phase, but you do need those safety case reports looking at any risks and management of those risks. You need those safety case reports to get to final sign off pre-occupation from the regulator, so that's really important. The regulator will be issuing those assessment certificates when they're satisfied that the building complies, and the regulator is also setting out the requirements for mandatory and voluntary occurrence reporting. So this is really key for anyone who's principal designer or principal contractor. The mandatory occurrence reporting really is vital. If there's any safety issues that could cause multiple deaths or injury, you are obliged to report those to the regulator. And if you think someone else has done it, then you need to get a copy of it and make sure your records are up to date with all of that, because if it's not been reported, then there's sanctions and fines for that as well. So yeah, you need to make sure that you've got evidence that it's been done. Next slide, please. A couple more regulators just to have on your radar. We're having a new national regulator for construction products. That's still a little, it's not, it's still in development, really, that regulator, but just to say that is coming. Our UK and EU standards are currently sort of harmonised now, but the regulator will be coming in to ensure a more effective regime for construction products. They'll be doing market surveillance and enforcement against manufacturers. There'll be new rights to sue construction product manufacturers, and there'll be fines from the government for any manufacturers who don't comply with regulations. There's no real timeline for when we're going to get that regulator in place, but it's on the government's list. We're also having a new homes ombudsman, where the big residential developers are having to sign up to be members of this new homes ombudsman scheme, and really that's there to take complaints from new build homeowners, and they're likely to develop a code of practice as well on conduct and standards for dealing with code of complaints and remedial works and requirements in terms of workmanship. Next slide, please. So one of the key things that I'm going to be emphasising today is that everyone involved now in the construction phase is in procuring, planning, designing, managing or building any building are duty holders. You can't divest yourself of that, and it is imposed by statute, and your obligation is to take all reasonable steps, not just reasonable steps, but all reasonable steps to reduce the risk of fire spread or structural failure. You're obliged to be competent, and we'll come on to more about that later. But this really is additional to your existing duties under CDM. It's modelled on CDM, so a designer or a contractor can carry out both roles, and really it's difficult to see how you can do one without the other. So I think one of the key things you can do to prepare for this regime is really be mindful of your role as duty holder and everybody else's. You know, it's there to encourage everyone involved to take ownership of fire and structural safety in the buildings that they're building. Next slide, please. More on duty holders. As I've mentioned, it's imposed by the Act, it's mandatory. You can only be a principal designer or contractor if you're competent as a duty holder. It's difficult to see how you could do any works without acknowledging your duty holder role now. Your obligations are to ensure that any works are planned, managed and monitored as required during design or construction. There's a big emphasis on cooperation and coordination. You know, you can't just do your job and not worry about anybody else. You have to ensure that all other duty holders have got all the information they need. And certainly towards the end of the project, all of the fire and structural safety information needs to be collated for the purposes of your safety case report, golden thread of information, which you'll need for sign off from the regulator. Next slide, please. I'm not going to spend too long on this slide, but just to put this on your radar really, because it really applies for the occupation phase of high risk buildings. But you've got accountable persons and principal accountable persons, and they really look after the fire and structural safety of the building. Responsible persons under the fire safety order, their remit is to look to keep people on the premises safe. There's also building owners, landlords and developers who are being required to remediate historical fire safety and structural safety defects, and they may need to contribute to the building safety levy on new projects to fund remedial schemes. So it may be that a building owner wears all three of these hats, or they may have divested some of them to management companies and the like, but just to let you know that terminology is being used, so accountable persons, responsible persons. Next slide, please. Competency is a big deal now, and it's a little bit woolly still, but there are various standards being drawn up for the professions. There's been a lot of thought put into it, and we've got new competency standards for principal designers, principal contractors, and for building management professionals in the PAS 8671 standards. Key points to note is that trainees and apprentices cannot be duty holders. They have to be supervised by qualified persons. We've had various industry committees and that have been put together to look at each profession and draw up standards that can be benchmarked against. Certainly for surveyors and any designers, that there are standards that must be maintained. Next slide, please. One big point to note about competency is that in order to get regulator approval, the client has to sign various declarations to confirm that they are satisfied their principal contractor and designer and any other appointed persons are competent. So they will be interested in ensuring that their professional team have achieved the competency requirements relevant to their roles. Certainly the Architects Registration Board is bringing in a new CPD scheme for 2020. They've got new powers under the Architects Act 2020 to publish their decisions for periods of time on the register, which will be publicly available. And you've also got the Setting the Bar Competence Steering Group report that was published in October 2020, which lists out various professions and the requirements for all of them, and that was initiated by the Hackett report arising out of Grenfell. But this competency drive is very much still under development, and there's guidance still being issued for the professions. So do keep informed with all of the relevant professional bodies. You can see that there's going to be a slight tension here, bearing in mind skill shortages in the industry as well. Next slide, please. Moving on to evidence briefly then, as I've touched on the golden thread of information, but just to emphasise, it needs to be created, it needs to be gathered from the supply chain, collated and stored digitally. The client needs to have it. All persons involved in risk management in the building need to have access to it, and it needs to be kept updated throughout the life cycle of the building. So any further works will need to feed into that. As I mentioned before, the accountable person needs to produce a safety case report in regard to the occupation phase, but you need that as part of your building assessment certificate as well. That was part of that application. Key thing to emphasise really is the importance of everybody cooperating and collating and sharing the evidence necessary to obtain that certificate and sign off, and to inform the golden thread of information. Next slide, please. I think that's it from me, and so I'll pass you over to my colleague Catherine, who's going to talk you through some points about the approvals process, change management and sanctions, and legal claims arising out of the Building Safety Act.
Thank you, Emma. Good morning, everyone. As Emma's just said, I'm Catherine Andrews. I'm a partner in the team here at Birketts, and I'm going to look at building safety regulator approvals, the new change management process, sanctions that can be imposed, and the sorts of claims that we might see going forwards. Next slide, please. So the first thing to look at is the approvals and registration process, which is for the high-risk buildings. So as Emma's mentioned, there are 3 gateways, the first one being planning in the usual way, and then we've got these new gateways 2 and 3, which are the pre-construction and the pre-occupation gateways. So the regulations apply to the construction of a new high-risk building, building work to an existing high-risk building, or to a non-high-risk building, but it's being converted into a higher-rise building, and any material changes to existing high-risk buildings. So, you know, the whole remit of the sort of works we might be thinking of in connection with those types of buildings. The Act, the Building Safety Act, introduced what we call hold points, which are these gateways. And this in practice means that the health and safety executive will require assurances before building work can commence, before a building can be certified as complete, and before the building can be occupied. The gateway should be seen as focusing upon whether relevant duty holders are fulfilling their roles and responsibilities correctly, and Emma's discussed that already. Just to emphasise that whilst procedures may be changing, the functional requirements of building regulations will remain the same. The biggest change is that the information required is significantly more comprehensive and must be produced at an earlier stage, which will be key for all members of the project team. We appreciate that paperwork isn't typically a favourite pastime of the construction industry. The key takeaway here is that responsibility for compliance sits with those responsible for doing the work. And the building safety regulator will have the ability and a duty to challenge the safety of the building through the entire process, from the initial design phase to the in-occupation phase. This will ensure that when a building is being designed, it is designed with the utmost safety in mind, which is reflected equally in the construction phase. If the building safety regulator doesn't feel that they have got the relevant assurances, then they've got powers to intervene, as we'll see. The registration process, as Emma mentioned, was opened in April this year, and the deadline was the 1st of October. So that's now passed, and all high-rise buildings must have been registered. Failure will be a breach of the Building Safety Act. So from the 1st of October, the Building Safety Regulator has become the building control authority for these buildings. And therefore, if you're developing a high-rise building in England, you must apply for building control approval from the Building Safety Regulator. Looking at the gateway stages, it is important to consider the whole process from the outset. This means that before you submit a building control approval application, you must review how you are going to construct your scheme, manage change, and meet the functional requirements of the building regulations. You need to consider this at the outset for the whole project, from design to completion and from procurement to handover. So looking at the gateways in a little bit more detail. So gateway 2 is before the building works start, and you need a building control approval application to be submitted with the building safety regulator and approved. Work can't commence without the approval. And to note here that the current indications are that the regulator will have 12 weeks to determine an application from its receipt. So this needs to be considered in your programming. If there's any delay, who is going to be responsible for that delay? The applicant is required to articulate how any standard or document cited in support of the application allows functional requirements to be achieved. Please note that any information in support of an application forms part of the golden thread of information that must be maintained throughout the project. The client has a high-level overall responsibility for ensuring the arrangements are in place to create and manage the golden thread through design and construction, but it's the principal designer who will manage the golden thread on a day-to-day basis through the design phase of the project. The list of anticipated documents that must accompany a Gateway 2 application will include a competence declaration, a building regulations compliance statement, a fire and emergency file, and a construction control plan. The building safety regulator needs to be satisfied that the proposed building works comply with all building regulations. They need to see a comprehensive description of the proposed works, a detailed plan, and a design and build approach document, meaning earlier design information will need to be available than might otherwise have been the case. The document must be updated throughout the construction period. Updated versions will need to be presented to the building safety regulator as part of the next stage, which is Gateway 3. So for Gateway 3, once work is complete, a building completion certificate application must be submitted and approved. This must contain sufficient information to show how the building conforms to the approved design and satisfies all the applicable functional requirements. Note again here, there is an 8-week determination period from receipt of the application. So again, that needs to be factored into your programming. The building safety regulator will carry out final inspections of the building work. A completion certificate is required before the high-rise building can be registered and then can move to the occupation phase. Next slide, please. So change management is a key feature of the new provisions. Before you can start any construction works, the design will need to be complete and a change control plan must form part of the application for Gateway 2. The new change control regime also came into force on the 1st of October and again applies to all high-risk buildings. The government's explanation confirms that the change control procedures will apply where there is to be a change as to how a project is managed or to what is being constructed compared to what was approved through the Gateway 2 building control approval application. So if you are changing any works that are deemed a major or significant change, you will need to submit a change control application, which must be consented to ahead of those works being undertaken. As set out on the slide, there are 3 types of controlled change. So firstly, you've got your recorded changes. These are changes which are not notifiable or major changes, but they must be recorded in a change control log in advance of the change being made. So these are essentially more minor changes. You've then got the next level up, which is the notifiable changes. Before these changes can be made, a notification must be sent to the building safety regulator. The change is recorded again in the change log, and any documents affected must be revised and will again form part of the golden thread. The building safety regulator may request more information. The HRB procedures regulations set out a fuller list of what might amount to a notifiable change, but for example, this might include changes to the construction control plan or the change control plan, changes to the layout of a flat or residential room, changes to the number or dimensions of any openings in a wall, ceiling or other building element, changes to the wall tie, wall restraint, fixing or support systems internally, changes to the fire and emergency file or fire safety compliance information, or changes to a staged work statement. You then have the most significant changes, or what are termed major changes. Before these changes can be made, a change control application is submitted to and approved by the building safety regulator. The change is recorded in the change log again, and again, the documents affected must be revised to form part of that golden thread. Note that the building safety regulator has 6 weeks to determine an application. So again, this could impact on programming deadlines. And this is why we're thinking that it's going to be really important to try and have the design ready up front to try and avoid, as far as possible, these sorts of changes needing to be notified. Again, there is a list in the regulations, but for example, major changes could include, as you might expect, changes which increase or decrease the external height or width of the building, changes to the number of stories, changes to the structural design or structural loading for the building, to the number or width of staircases or to the length, number or width of any escape route, changes to the external wall, including the wall tie, wall restraint fixings or support system, and changes to active or passive fire safety measures. So you can see there the really key changes that might impact on safety and structural issues. Our concern here, as we've mentioned on the slide, is firstly delay, and secondly whether this will impact value engineering on projects, because it could be a false economy if you try and make value engineering changes during the project and you then have to wait 6 weeks each time you make such change for the regulator to approve the change, and the delay and the cost that will be associated with that process. Could I have the next slide, please? So moving on to sanctions for failure to comply with these regulations, as you might expect, they're pretty severe, reflecting the importance that is being placed on these regulations. The building safety regulator has powers to educate, investigate and take action. It can put a stop notice on the works. It can prevent occupation of a completed building if it's not satisfied, and it can reject an application for building control approval. All these could have a very significant impact on your project. The building safety regulator can also replace an accountable person with a special measures manager if there are serious failures endangering the life safety of residents, and has powers to hold building control bodies to account or to suspend or remove inspectors. Note also, as is on the slide here, that there are corporate and individual offences. So individuals can be penalised for example, failing to comply with a duty holder role. And it's quite important to note here that this could be any officer of the company. We're not just talking about directors in the legal sense. The sort of prosecutions that the building safety regulator can bring would be for obstruction, prevention, providing false or misleading information, failure to issue required notices, non-registration of the buildings, as we've just looked at, and again also occupation of a building without the relevant Gateway 3 process certification, as well as failing to display prescribed information. Note that fines are unlimited, and there is actually a potential for imprisonment of up to 2 years in serious cases. We're obviously yet to get any real feel for how these provisions will be applied, but they're clearly requirements that need to be taken very seriously. Next slide, please. So it's anticipated at this early stage that the new regulations will lead to an increased risk of civil claims as well. This could be claims against any duty holders and will include claims for breach of the construction products regulations if a building is found to be unfit for habitation, or claims where works are found to be either non-compliant with building regulations or have failed to provide a habitable dwelling. As Emma touched on, the Construction Products Regulations claim is a wholly new right of action brought about by the Building Safety Act, which relates to defective construction products. The Act creates a right to take action against construction product manufacturers and suppliers for breach of the regulations that causes a building or dwelling to be unfit for habitation. Liability also arises if a person marketing or supplying a product makes a misleading statement in relation to that product. For example, an obvious one would be, the length of time that the material has for fire safety. The limitation period for these claims is 15 years prospectively after June 2002, but for cladding products, there is a retrospective limitation period of 30 years. There is, however, a buffer period of a year for claimants getting close to the cut-off point. Obviously, we don't yet know exactly how this new right of action is going to work until the courts have had a chance to consider it, but there is one last unusual provision that shows how far the government is prepared to change the law to assist potential claimants. The government has given itself the right to order that defendants pay a just and equitable amount towards the claimant. How and in what circumstances this might be used has not been explained, so watch this space. With claims in mind, I then wanted to touch on remediation orders and building liability orders, which are new, again, under the Building Safety Act. So under the Act, there is a regime whereby the first tier tribunal can make a remediation order requiring a relevant landlord to remedy a relevant defect, as defined in the Act, in buildings that are at least 11 metres high or have at least 5 stories and contain at least 2 separate dwellings. There is a recent case in this area of Waite and others v. Kidai, which was the first case which went before the first tier tribunal where such an order was made. Such orders may be sought by leaseholders, but can also be made by the Health and Safety Executive, a local authority, or a fire and rescue authority, amongst others. In the Waite case, the application was made by a group of 5 leaseholders who sought an order for the landlord to replace defective cladding. The tribunal found that the provisions of the Act were drafted very broadly and gave them a wide discretion to exercise their own judgment in deciding whether an order should be granted, including through inspection of the building, its own experience of similar matters, and any evidence put forward by the applicants in the way of expert reports and the like. Interestingly, they did not agree with the landlord that the applicants were required to evidence all defects and propose resolution for those defects. Following on from this, in relation to the actual works to be completed, the tribunal also found that for largely practical reasons, it was not to be the responsibility of the leaseholders to dictate the exact remediation required or to prepare a scope of works. Nor did the tribunal itself have to set out specifics of the works to be carried out. The responsibility and cost of setting a scope of works will therefore typically be borne by the landlord. This is consistent with the approach of the Act, which is seen as being very leaseholder-friendly legislation, with the overriding principle being to ensure the building is safe and to protect leaseholders as far as possible from the costs of making it safe. The Act also includes a regime for remediating contribution orders, which is to make orders against associated companies of the landlord if it is just and equitable to do so. Again, this year we have seen a case of Arjun Batish versus Inspired Sutton, where the tribunal did make the first remediation contribution order. This was an application to recover service charge already paid towards the remediation of defects under 15 separate leases. It was accepted that the service charge should not have been used for the defects, and a remediation contribution order was made against the freeholder and the developer. Just moving on then to building liability orders, which again is a new opportunity under the Act. So the government has introduced building liability orders to address the possibility that certain developers might escape civil liability for safety defects because they've carried out the projects through a subsidiary, a shell company, or an SPV that has very few assets to go for in a claim. Such companies might own and manage an individual development but have limited covenant strength and are often wound up at the end of the project. This results in no long-term civil liability. So the High Court can now make a building liability order to extend the specific liabilities excuse me, of one body corporate to any of its associates and make them jointly and severably liable. The aim is to ensure that the original developer still funds remediation works. A building liability order may be made in relation to any relevant liability. So we're looking at claims under the Defective Premises Act and claims under the Building Act, resulting from a building safety risk. And building safety risk is defined as a risk to the safety of people in or about the building arising from the spread of fire or structural failure. So whilst we don't yet know how this will be interpreted, we're talking about structural failure as well as fire. So section 130 will have retrospective as well as prospective effect. Therefore, a liability order can be granted in relation to a relevant liability that was incurred prior to section 130 coming into force, which was in June 2022, provided the limitation period for that potential claim has not expired. As I mentioned, the court will make a building liability order if it considers it just and equitable to do so. There is no guidance on the meaning yet of just and equitable, but it is understood that factors that will be taken into account would include the nature of the defects, the extent of the damages sought, and whether a fair trial can take place. The court will also look at whether claimants have other methods of recourse, such as insurance, but there will be further guidance coming through in the case law as these cases develop. So if an order is made, then the relevant liability of one body corporate is also the liability of another. Now, a body corporate is associated with another body if one of them controls the other, for example, a parent company, or if both are controlled by a third company, for example, a sister company. There are details within the Act about what constitutes control. The Act also refers specifically to limited liability partnerships as well, but neither body corporate or LLPs are defined in the Act. So there will need to be some further judicial consideration on that potentially. Linked to these liability orders, there are applications that can be made for information orders. So this is where you're not quite sure whether there is an associated or a linked entity, and you can require that original entity to provide information so that you know if there are other opportunities for parties in relation to who a liability order can be made. So given the nature of UK construction projects and property development, these provisions are likely to prove extremely useful to claimants, especially when dealing with historic corporate structures and dispositions. There's no information about how or when to apply for this these orders, and it's currently unclear whether you have to establish liability first. The wording of the Act suggests you might, but the government guidance would suggest that you can seek an order pre-action. So if I could have the next slide, please. Just conscious that we're getting towards time for my slot, but just to mention the Responsible Actors Scheme. So this was launched in July 2023, and it's aimed at major residential developments with average annual operating profits of 10 million or more. Other criteria that must be satisfied is that 50% of their adjusted operating profit is derived from residential property development, and that they've been responsible for the development of one or more buildings during the relevant period. if those criteria are satisfied, then any developer must join the scheme. If they don't, or they don't comply with the scheme, then they will be subject to building control and planning prohibitions. This is really significant because it could mean that they're unable to undertake further development works. So developers must join and comply with the scheme. And we understand that this scheme has the potential to be expanded over time. So we need to watch out for developments in this area. If I could have my next slide, please. So just some final thoughts and sort of ideas on preparation in light of these new rules. As we've mentioned, this could end the procurement process whereby contractors are going to finalise the design at a later stage, because we've seen that would be a problem for the gateway to approval process, and then change management that might be needed. And likewise, is this going to change value engineering practices for high-rise buildings, because any changes would need to be notified and approved, thus delaying projects during the construction phase. So to be ready, we recommend that relevant members of the project team must take ownership and manage their risks. You need to review your people, your systems, and your data storage so that you can retain all the relevant information needed for the golden thread. It's important to review goods and materials you're going to use or specify to make sure there are no specific risks to take into account. Consider what training and supervision requirements are needed for your teams. Consider very carefully all the documentary requirements to inform the golden thread, because this is going to be significant, and as Emma mentioned, cooperation is needed. Understand and get used to the new key definitions of duty holders, accountable persons, competency and stakeholders, and anticipate the impact on the high-rise, high-risk buildings for developers' cash flow as completions are delayed pending certification by the building safety regulator. If I could have the next slide, please. So these will be in the slides that we're going to send out to you after the webinar, just some further reading links that might be useful in your preparations. I'm now going to pass back to Kane for his final thoughts and summing up. Thank you.
Okay, many thanks for that, Catherine. Yes, so next slide, please. So I'm just going to talk about what we've done as T&B, really. So, and I hope you're giving insight and some sort of tips as to what you might be doing yourselves as to how to prepare for these changes, some of which are, a lot of them are already in force. And really, T&B contractors, we don't tend to work on high-risk buildings. So where we're coming at it from is the things that apply to all buildings. However, we do very occasionally work on high-risk buildings. Therefore, our estimating teams and all those people that are looking at these jobs as they're coming in through the door need to be aware of what the definition of a high-risk building is, so that then they can understand that these things might apply to those jobs. So where we're working on existing buildings, doing some refurbishment type works on those high-risk buildings, that's the kind of work we might get involved in. So we've had to review our procedures. Obviously, a key part of the responsibilities of duty holders are now incumbent on us as principal contractors, but we also might act as principal designers and contractors. So understanding those responsibilities and making sure that those responsibilities are mirrored and explicitly identified within our procedures. So a good example is making sure that those competencies are detailed in our job descriptions, in our safety policy, those kind of things. Making sure that we have hold points, that our building safety regime is identified within those hold points. So I think very much so, although word safety is within the Building Safety Act is very much in relation to quality. So it's trying to make sure that the building is built right, that it is safe, and the safety features, the fire risks, the fire stopping, the structural elements are all built properly and work properly as per the design intent. It's making sure that those quality aspects are done right. So again, making sure that we've reviewed our quality management system, making sure that we've explicitly focused on those risk elements so that our project teams are have got the right stages to sort of say, yes, we are sure that we are complying, we are sure we are complying throughout the project. And that applies to the design teams as well. So we don't tend to do the design, we tend to contract that out. But again, those designers were just having to make sure, they will have to make sure in the same way that they are focusing on those building safety aspects to make sure that they are compliant throughout their process. So coming on to reviewing, that's reviewing procedures, reviewing competency. Obviously there's these, again, new competency requirements. I think Emma mentioned that the new public available specifications 8671, 8672, 8673, which are which detail out those competency requirements for certain aspects, for certain for the principal designers, principal contractors, and works in residential buildings. I think they're being developed on, and again, Emma mentioned that it's a bit of a moving feast in relation to competency. But again, we've just been reviewing our competency arrangements. Is it explicit within our, we have something called an SQ1, a subcontract questionnaire. So are the competency requirements about building safety, when we're bringing new subcontractors on board, have we really focused in on that as we do with safety under CDM? And the answer was no. So we've added in questions in relation to competency around particularly building regulations compliance for our supply chain. So we're now asking these additional questions. It's worth noting on that as well, keep an eye on the Common Assessment Standard. A lot of people wouldn't be aware of SSIP and PAS 91, which is the public available specification. The Common Assessment Standard is taking over from that, and in March next year they are planning to have new questions that incorporate the Building Safety Act into that Common Assessment Standard. So again, you can probably look through that and cherry pick out questions out of there if you want to be thinking about how your own supply chain onboarding system works. Obviously, from our perspective, if they've got a Common Assessment Standard certificate already in place, they can sort of skip some of our questions. And as I say, we needed to review our own projects. So have we worked on, have we got any high risk buildings? Is it that I think there's a potentially a lack of knowledge within the rest of the industries. There might be clients out there that don't realise that their buildings are high risk buildings. We've seen that ourselves, whereby the client, we don't think, is aware that their building is a high risk building, and they're asking us to tender for works on that. Now, that's the big risk to us. If we go ahead and work on that building without all the necessary building control applications that the high risk buildings now require, you know, that it wouldn't receive building control sign off. So it's a risk to us, it's a risk to our clients. So it's making sure that we're aware of what those requirements are so that our estimating teams can take that into account. And of course, there's loads of information out there that Catherine's already mentioned, some of the sort of websites and things like that there are. There is the HSQE, as we know, the Building Safety Regulator, they've got their own. And again, there's an update service there that you can log on to and get emails directly into your thing. It is a moving feast. There are things going to be coming out from this Building Safety Act for years to come as people get their heads around exactly how it works. And I think we will be having more of these type of sessions with various different people that I'm going to be attending to find out what's going on, really. So that's how I'd say to prepare, and that's what we're doing as an organisation. Next slide, please. Next slide, another next slide. So next slide, please. So yes, question time. So people's questions have been coming in. So I've been looking at that as we're going along. So I'm just going to bring back in Emma and Catherine, who are hopefully going to help me answer these questions, the ones that I don't know, which is almost certainly going to be all of them. So I've got one here saying, does the golden thread, this has come a couple of times actually, does the golden thread apply to all buildings or just HRBs, high risk buildings? I don't know if Emma or Catherine, who wants to take that one?
Yeah, I would just say technically yes, it's just for high risk buildings, but I think in practice it's likely to be a requirement for more than just high risk buildings. I think it's a good habit to get into generally as well. There's a lot of clients that are going to require it as of routine, I should imagine. Catherine, do you have anything to add?
No, I agree. Yeah.
I would just add to that we are already seeing questions on that in our tenders. So we're being asked the questions on high risk buildings for jobs which aren't high risk build. We've been asked a question on the golden thread and how we provide our information in line with the golden thread on jobs which aren't high risk buildings. So it does feel like it's going to be more of an industry standard than just apply to high risk.
Yeah, I think the point is, if it's not a high risk building, it should be more straightforward to compile the golden thread, but you know, still got to do it.
Yeah. One of the interest to me is for works on existing high risk buildings, do the gateways apply, and or are there any transitional arrangements?
Yes, I would say the gateways do apply, and there are transitional arrangements. I mentioned the date was 1st of October 23 for planning. So if you've got planning before then, and if you've started permanent building works by the 6th of April 24, then you wouldn't have to go through those gateways 2 and 3. So
if you don't have planning now, then
you have to do
we'll
it, yeah.
have to go through the gateway 2. So that involves even for works on existing, so any works on an existing high risk building, you'd have to get approval from the building safety regulator, and there's a whole change management process there around applying to the building safety regulator for any significant major, is it major changes as phrase, is that
major,
right?
Yeah, that's right, yeah.
Okay, that's interesting, thank you very much. And this
I think
is
there's one for oh, sorry, Kane, I just saw there's one for you in the chat saying that you mentioned the designers are more focused on building safety design aspects. Can you provide an example of systems or documents provided to demonstrate this?
Oh, crikey. So we see risk registers quite often in our from our designers from a CDM perspective, and they're very interested in the CDM, making sure that those CDM risks are accounted for. I would think that's a natural progression to add
extension to that process.
Building safety into that process. So I would see that coming in much more in line with that. Principal designers was an interesting question as to whether or not principal designers, at the moment they provide pre-construction information, or they assist the client in providing pre-construction information, I should say, whether or not there will be a separate document, or it's often what they provide is a pre-construction information pack or document, whether they provide a separate pre-construction information pack or document in relation to building safety and building regulations compliance. I'm not sure whether that will be something that would come in, but again, those principal designers need to think about how they're going to satisfy the duties of the of this Building Safety Act.
That's right. I think that information will need to be probably expanded upon, won't it, to make sure that all the requirements are covered for the more specific information that's needed.
Yeah.
Again, hopefully it's nothing new, it's extensions to what people are already doing.
Yeah, yeah. And one final quick question, which was in relation to behaviours, which I understand is one of the requirements for all parties. So they need to demonstrate appropriate behaviours now, which is similar. Under CDM, you've got skills, knowledge, experience, and organisational capability. Under the Building Safety Act, they've added behaviours. How do we demonstrate or assess behaviours?
I think it's all part of competency, isn't it? It's part of the training, it's a part of your general approach and communicating and coordinating with other duty holders.
Yeah.
Taking ownership, really, I think is the key thing.
And I do know on behaviours that there are questions going to be added to the Common Assessment Standard question set, which is due to come out in March of next year. So again, keeping up to date with these things will help to sort of make these things a bit clearer as to what the expectation is, or what the industry going forward is going to sort of come up with to satisfy these requirements. So, okay, I think we're out of time. There are more questions, but we'll endeavour to answer any of those in the information we send out. So all it leaves me to do is say thanks ever so much to Emma and to Catherine for being the experts on the panel at this webinar, and of course to Natalie, who's in the background there making all work and tick. So many thanks to everyone. I hope you found it interesting and useful, and take care. Goodbye.
Thank you.
Thanks for listening.